All right, not so boring in the nation's capital these days, particularly when it comes to personal relations and a divorce proceeding that's going on there. Making news on this Wednesday afternoon, a 55-year-old Ottawa businessman and a one-time mayoral candidate apparently went to extremes when it came to his divorce and his divorce settlement. Bruce McConville shocking a Superior Court judge the other day when he actually told the court that, he went to the bank, withdrew $1 million, and then burned it in 2 bonfires in his backyard. So his ex, soon to be ex, I guess, couldn't get any of the money. Now, first, what do you do when you go and get $1 million cash from the bank? I mean, you got to phone ahead, right?
It says that he went 26 different times, and that multiple banks. I think 6 different banks. So this was like a huge procedure.
Okay, because I was thinking this is just not like an ATM withdrawal. I mean, it's well over anyone's daily limit. It's well over the limit of what's in any ATM. And you just, I don't think, can stand in line and next teller available. You get up there and it's like, yeah, I'd like
a cool million.
Yeah, $1 million out of my checking, if you wouldn't mind, please. You go and sometimes you want like $500 and you have to wait for the timer on the drawer to open up. Could you imagine how long it would take to get like $1 million together?
Days.
Yeah. So that's part one of this scheme or this plan. But part number 2 is setting fire. Like, did he basically, do we know, treat his $1 million in cash kind of like, leaves in October, where he sort of gathered them in a couple of big piles and then set those leaves ablaze? But in this case, the leaves were actually, $1,000 bills. It's
funny, though, when you think about the fire, because with our new bills, it's just like a plastic fire, isn't it?
Well, yeah, because they're kind of coated, right? And they're slippery now. So, yeah, I don't know how tough it would be to actually set that money ablaze.
Imagine relaxing by that bonfire, though, just hanging out,
I don't think you could be relaxed. That's $1 million going up in flame. Anyways, the judge, Jackie, apparently didn't believe him when he told the story, when McConville told the court this.
Yeah, I guess, who would believe that at first go, right? So, yeah, the judge didn't believe him, kind of questioned him on it a little bit more, and was appalled enough that he sentenced him to 30 days in jail to show the severity of it, and to, obviously to obey the court ordered.
Wait a minute. He put him in jail for burning his own money?
He wasn't obeying court orders. This is what he did to go around it, and so the judge sentenced him to 30 days to show the severity of it and the importance of obeying court orders.
All right, let's welcome in Rick Patika. He is a family lawyer at Shulman Partners, and he joins us now for more here on Global News Radio 640 Toronto. Rick, I'm sure in your long, distinguished legal career you've seen some things, but have you ever heard of anything like this?
Hi, good afternoon, Jeff. Thank you for having me. Clearly, this is one of the exception of cases, specifically when it comes to someone who goes out of their way to disobey court orders. So this is really a one-off extreme case.
Yeah. So what would the court order have been? Would it be like assets are frozen? Does that typically happen in a divorce proceeding, that because he took the $1 million out of the bank that he disobeyed the court?
Well, likely there should have been a freezing order or a preservation order in place by the time. As I read the article, Mr. McConville was before the court on a contempt motion, basically for defying the previous court order. So presumably he was there because there was a preservation order already in place. But clearly he voiced to the court that he went out of his way to disobey the court orders and to burn his assets on 2 separate occasions. So.
No kidding. I can't even imagine, never mind having $1 million cash, but then setting it ablaze, setting it on fire. What does this do, Rick, to the proceedings and to the other party here? Does his partner, do they still have a claim to the assets, even though they've now gone up in ashes?
Well, they have a claim. The claim is there. It's not finalized. The judge did say that he didn't believe that he actually set ablaze his money. Likely, it's clear that he's putting it beyond the court's reach, and they'll probably have to do some sort of forensic investigating as to where did all this money go, and if in fact that's true. And if it's not already in place, there is going to be an order freezing his bank accounts and any other assets he has. So that's probably the next step that will occur.
All right, well, fair enough. I mean, this story is just so fantastic. You can understand the skepticism of the court and others. So I guess the first thing they have to do is investigate, get to the bottom as to whether or not he's just put this money somewhere else or actually did set it on fire. If he set that $1 million on fire, how does that affect the proceedings and the division of assets? Would it still be divided as if the $1 million was still there? Because it's really not the other party's fault that it's no longer in the bank.
Well, the wife is likely going to be looking into his other assets. If he has other real property, they'll be looking to take that, assuming that actually did occur, that he actually burnt $1 million of cash, that they'll be looking to take that money from his other assets to the extent that they're able to do so. So.
Well, fair enough, but $1 million is still $1 million. I mean, is that literally up in smoke now as far as his wife is concerned, the other party? Because, I mean, part of the divorce proceedings and the argument is, an equal and fair distribution of assets. And again, through no fault of her own, if this did indeed occur, there's $1 million less worth of assets.
Potentially, there could be, and some of that may be attributed towards not only an equalization of assets, but also to determine what was his income for purposes of child support or spousal support, and some of it also may be attributable to support as well as division of assets.
All right, just finally, Rick, what should this tell the average person? I mean, they're sitting back, listening, hearing the story, shaking their head in disbelief. But as best you can, if you ever find yourself in a situation, I mean, whether it be a divorce or any other sort of dispute that might involve finances, is to try to remove the emotion out of it?
Basically, remove the emotion, come to grips that the separation is over, move towards an amicable separation to the extent that you're able to. And if there's court orders in place, obey them, obey them, obey them. Don't thumb your nose to court orders and thinking that you're going to run away from a court order. It's not going to help.
All right. Rick Patika, family lawyer, with us this afternoon. Rick, I really appreciate you coming on. Thanks so much.
Thank you for having me. Take care. Thank you for having me.